Welcome back and welcome to Focus on Health Law. This will be illustrated here by Mr. Kenneth Haber, who is an internationally renowned attorney at law. Today, Attorney Ramesh Khurana of the Khurana Law Firm has a bucket full of questions for Attorney Haber regarding the original Medicare and its appeals and backlog. Let's hear out these two attorneys in their legal dialogue.
Hello, this is Ramesh Khurana, attorney at law. I have my office in Gettysburg. Today, I am really pleased to welcome my friend and a very experienced and knowledgeable lawyer, Attorney Ken Haber. Welcome to our studio, Ken.
Thank you, Ramesh. My pleasure.
Great. It's our pleasure to have you here.
Well, it's my pleasure to be here.
Ken is the former assistant U.S. attorney and the former senior attorney in the office of Inspector General. And we are lucky to have him here to answer questions about Medicare. Now, I'm going to ask you a question about the original Medicare. I understand there is a lot of appeals backlog. Do you agree?
That's putting it minimally.
Okay. Now, can you please explain the reason for the appeals backlog and what is the current status of the Medicare appeals backlog?
Well, the appeals backlog, officially they're acknowledging 700,000 at this point.
Officially?
Officially. But previously it was acknowledged at 800,000. They're adding 15,000 a week cases to the appeals system. I don't see how the same judges have knocked it down to 700,000. There could be a certain amount of attrition where people may just withdraw their appeals, but you're not talking about 100,000 of those. I think that it's incorrect disinformation that the agency is putting out to try to convince Congress that there's no crisis anymore. There has been some amelioration of some of these appeals in terms of the hospitals where they're trying to settle a number of them, but the average doctor on the street, the private practitioner, has no relief. His money is being tied up in these processes. He's not getting paid. And it's just a very, very bad situation because the payments have been cut down, and then not only have the payments been cut down, then they're cutting back in terms of these recoveries that they're demanding, and a variety of other mechanisms to try to gather together $500 billion that they said was waste, fraud, and abuse in order to pay for the Obamacare, when there was not $500 billion of waste, fraud, and abuse.
And I remember you talked in detail about this concept.
Yes, yeah. So I mean, it's just causing a big backlog, and no one has stepped up to the plate to try to fix it. Not for the average doc. The hospitals are critical that they have to keep the hospitals going, so they've made some adjustments there. But the average doctor who's practicing medicine is just being adversely impacted without proper justification, as far as I'm concerned, and that's why there's a big appeals backlog.
Okay.
It's not going to go away anytime soon because most people are pretty upset with what's happening to them.
Okay, not a good situation in regard to Medicare appeals backlog
No.
at this point. Okay. Now, let's talk about what are the levels of appeals for providers as to denied claims.
It's discussed, it's talked in terms of 5 levels of appeals. That goes up to the U.S. District Court. There's actually more because of the fact you can go to the Court of Appeals and you can even go to the Supreme Court, but for practical purposes, you're talking about 5 levels of appeal. The first level of appeal is at the contractor level, and that's when the Medicare contractor makes a determination, and then the appeal would be a redetermination. it's made by different people theoretically within the same contractor. The second level of appeal would be by a qualified independent contractor, what's called a QUIC. We had a case not all that long ago where a client was being denied payments by a Medicare contractor, and let's call it contractor A, and the appeal went to a QUIC, and the QUIC has a medical director just like the contractor has a medical director. And the QUIC's medical director, and let's call the QUIC B. The medical director of QUIC B was a medical director in a different state, but for the same QUIC A, not QUIC A, but contractor A, but a different jurisdiction of contractor A, but in a different state. So I mean, like, you got the QUIC B medical director being paid by the Medicare administrative contractor A, but in a different state than the other. So I mean, it's not what you call conflict free.
Okay, now Ken, when you are talking about filing a reconsideration request, now my question, is there any time limit within which you have to file for reconsideration?
Yes, yes. At the first level for the redetermination, you're supposed to file within 120 days. The second level, you have 180 days. Now, they're at the first level supposed to make a decision within 60 days. And the backlog's really not there. And the backlog's not even at the QUIC level where they make their reconsideration, their redetermination. The real backlog is when you go beyond the QUIC and you get to the administrative law judges. They just have a few of these people who are in fact highly trained. But you know, how can, you know, let's say that they got 100 of them. You know, and I don't really have in my mind the exact number, but it is in thousands. It's within 100, 200 or whatever.
Has there been recently increase in the number of ALJs?
No.
No?
No. And that's the third level where you get to be going to an ALJ.
Right.
And you have 60 days in which to file your appeal to the ALJ level. And the ALJ theoretically has 90 days in which to make a decision. But they don't even see the cases
in 90 days.
It's backlog there. You got 700,000, 800,000 cases. And the next level you can accelerate to the fourth level of appeal, and that's the Medicare Appeals Council, which is ALJs once again, limited number of ALJs. And the Medicare Appeals Council is interesting because the Medicare Administrative Contractor's initials acronym is MAC. Medicare Appeals Council is Medicare Appeals Council, MAC. It's also got the acronym of MAC, but it's the Appeals Council. They have 90 days in which to issue a decision as well. Within that, after they issue their decision, you've got 60 days in which to file your appeal. Now the thing is that you can escalate at these levels. You can jump over them if they don't do it within the time frame.
Oh, really?
Yes.
If ALJ doesn't make a decision in 90 days, you can go to the U.S. District Court?
You go to the MAC, to the Medicare
to the
Appeals
MAC.
Council. And then if they don't make their decision in 90 days, then you can file with the U.S. District Court. The difficulty is these are the fact-finding levels, you know, where the ALJs are. And, you know, if you escalate past them, you know, what you have to do at the initial levels is package your case sufficiently and package it with enough of interpretive, you know, with enough experts giving opinions. And most contractors don't have the slightest idea of how to do this in order for a U.S. District Judge, who then gets to file cold without an administrative law judge giving opinions or making any decisions. And that U.S. District Judge has to then make a decision on the record.
Right.
because he's not going to go and have hearings on all these cases, and it's supposed to be just appeal on the record.
That's why there is a need for a sufficient record before it goes to the U.S. District Judge.
Yeah, and you need to package it properly and get the expert opinions properly, so that on your record and your briefs and everything, you
So
can
basically
convince
you
the
get
judge.
stuck with the ALJ level.
You get stuck
because
at
you
it.
cannot sufficiently package
Well,
it before
most people can't.
Right,
What
I
you
know.
need is a good qualified attorney
Right.
who knows how to do it, and then
Right.
you have a chance
Yes.
to have a U.S. District Judge review it
sense.
and make sense out of
Yeah,
it,
yeah.
and say, yes, if there's problems here and it's packaged properly, and I can understand these experts, and I can understand their qualifications, and and the government hasn't done anything properly, so I'm gonna accept these experts' opinions on these, and I can see how they're making their decisions on these, and then you can beat the government at this game. But the government is just keeping it backlogged, and most providers don't want to spend the money to do what they got to do, and don't know how to do what they need to do in
So
terms of
once the
packaging it.
judgment is issued by the U.S. District Judge, so you can go to the Court of Appeals.
Well, you could.
How many days you have? 30
Probably
days?
30, 60
30,
days, whatever
okay.
the normal appeal
Okay,
thing is. It's
okay.
nothing special for
Okay.
these.
Okay.
But the fact of the matter is that you got to package it, at the very beginning.
Very beginning.
At the
Because
very beginning,
hearing
because-
is on the record. Right.
Yeah, theoretically, at the ALJ level, when you would see them, they'll take in new evidence.
Right.
But under the rule, they're not obliged to take in new evidence. So the government can argue that if you don't have it before you get to the ALJ, that you can't bring it up to the U.S. District Court by escalation. That you need to do it at the determination or redetermination or reconsideration level. So you need attorneys who know what they're doing at the very, very beginning to package your appeal for you if you're going to then go escalate it.
Okay. Very interesting.
It's a very complex type of situation, and it's the only way that you could possibly have any sort of relief, except for one type of situation. That's if you get injunctive relief. But most courts are not going to give you injunctive relief. They might give a nursing home injunctive relief. They may give a hospital, more likely to give a hospital injunctive relief. And why a nursing home or hospital? Because of the fact that if they don't get the relief, it can be very dysfunctional. It can be very intrusive on the patients. If the patients have to go get relocated, for seniors, it could be terribly devastating if they have a sort of a family within the nursing home, to have their family disrupted and torn apart. So you will see cases there where U.S. District Judges from time to time will issue injunctives for nursing homes. They'll issue injunctions for hospitals. And that's why the government is more concerned with taking care of those type of institutional providers than they're concerned about the doctors. So they consider the doctors a dime a dozen, and people can go to a different doctor. We tried to get an injunction not all that long ago for a doctor who had a very particular type of pain management practice where he was dealing with injections using fluoroscopy in order to pinpoint the fluoroscopy, and the U.S. District Judge was not concerned because they can get this elsewhere, but there wasn't any place else. The government came in and said, they can get it elsewhere, but there wasn't any place that was using fluoroscopy.
Great. Now let me ask you one more question. Now, how you can protect your claims if you keep on escalating them?
By packaging them properly,
Oh,
so that
okay.
you'll be able to explain them to the U.S. District Court, because there's not going to be a ALJ determination, that will
Which can
spell out
provide a lot of
things.
information to the U.S. District
So
Judge.
you have to do it at the
Right.
very beginning levels with your experts, and
Which will be more expensive, of course.
be
if you
more
want to
expensive. But
package.
the fact of the matter is that if you don't, you're going to lose your claims, or else they're going to sit around for years and years and years, and who knows what's going to happen to them.
Okay, great. I think we are left with almost no time now, and we have got to wrap it up, Ken. But I must appreciate you coming to our studio, and you have given answers to my questions, which audience is going to be find very useful. Thank you very much.
I thank you, and
Thank you.
I thank your audience for being there.
Anything you would like to say? We have just 20 seconds.
20 seconds. If,
Yeah.
if you're a healthcare provider, you need to get yourself a good attorney who can package your claims, because you're not going to get relief, through the MAC. You're not going to get it through the ALJs, because they just can't handle the volume that's coming in, because Congress has not made a serious attempt at fixing it.
That goes without saying. You should always talk to a very experienced and knowledgeable lawyer if you have any issues. Thank you very much for being with us.